So I'm sorry about the difficulty. The point I was making was it is important at the outset to distinguish between the actuality of conflict and the perception of conflict. The consequences are different, and too often we tend to blend them. Now, in terms of the perception of conflict, you're dealing not with a conflict situation that has actually arisen, but you're dealing with a set of facts that create a perception, that creates a suspicion that there may be conflict having arisen. And then you have the actuality of conflict. What the law prohibits in the 4 is the actuality of conflict. And in the terms of the actuality of conflict, a person alleging that there has been conflict has to provide the factual basis supporting the allegation of conflict. And the factual basis here implies the fact that there is a relationship between a decision maker and a beneficiary of the decision. And the decision maker's relationship with the beneficiary of the decision is of such a material character that the beneficiary of the decision maker has benefited or would benefit from making that decision. So in terms of the perception of conflict, the law doesn't, so to speak, ordinarily prohibit it, but the law counsels against it. And so, for example, if a person who has a decision-making authority engages in an act which is deemed or could be deemed to create a conflict situation, that raises ethical issues, that raises officialdom issues, and other issues that, as it were, undermines the authority reposed in that person as a public official to take that decision. So when it comes to perception of conflict, the key and the most important thing in prohibiting the perception of conflict are the issues of disclosures. And so one has to disclose, for example, the relationship that he has with someone who stands to benefit from a decision that is being taken. Now, having made this point, and in the context of the investigation, it is important for us to also remember, and I think Mr. Vitus Azim made a statement that may be closely related to this. It is important for us to remember that holders of public office have relations, and those relations have agencies. In other words, they have relations who are autonomous and who do not take instructions, so to speak, from the holders of public office. So what it means is that those relations can ordinarily do all kinds of things that ordinary people do, including bidding for contracts from the state. It is also therefore the reason why we have strictures or we have limitations placed by law in the exercise of these powers, including procurement powers of states. So the most important thing is, if you have the relation of the former president bidding for a state contracts, the former president cannot, by law, prohibit his brother from bidding for state contracts. What the former president can do, of course, is to do his possible best to distance himself from the transaction as much as he could. There are circumstances where he can't because the law mandates that he takes certain decisions. And so for those ones, he would have to take the decisions. But where he could, he distances himself as much as he can. Number 2, appropriate disclosures. If, for example, the contract would have to go to Parliament, if the contract would have to go to any other body for consideration for the matter, what the former president can do is to disclose. But even more crucially, what the beneficiary of the contract can do is also to indulge in appropriate disclosures. But beyond these, the former president cannot of himself prevent somebody who's of full age and capacity and who has agency and autonomy from participating in state benefits that the person ordinarily has entitlements to participate in. One other difficulty for this particular contract, and which is perhaps why the OSP's conclusion is what it is because it is a specialized area of contract. It is not an ordinary commercial contract. You're dealing with the procurement of aircraft or aircraft spare parts. There are few entities in the world that are in those areas. And what that means is that in terms of procurement, you are not likely to get many entities even bidding for this. So as to whether or not the state could have decided that within a range of options, the state is abandoning a particular bidder and going for another bidder. And the reason being that that bidder has a relationship with the president, for example, as to whether the state had that choice. The dynamics in this particular circumstance will not be the same if, for example, the state was going out there to buy, say, textbooks for students in secondary schools or universities. So some of these things can create complications. And while, therefore, conflict of interest is something that has undermined Ghana in many ways for many, many years, it is important to also have the nuances clarified. And those nuances must reflect in the discussion so that we do not ask for a jump.
Okay, so the discussion is getting to turn on conflict of interest. But first, establish some legal principles for me from where you sit, your many years of practice at the law, teaching the law, and training people in this area. When you do the agreements that these countries did with Airbus, does it mean automatically that you are guilty of an offense?
I suppose you are speaking of plea bargaining?
These were deferred prosecution agreements, what? Consent agreements, and whatever agreement. They are in the nature of plea bargain.
These agreements have different nuances in the jurisdictions in which they are made. So, for example, in America, they have another one they call the no contest plea, where you basically plead not to fight the case, so to speak. In my understanding, and respectfully to my colleagues, these agreements do not amount to an admission of guilt. These agreements are statements of a person who signs them that I'm not going to go through the process of litigation. I'm not going to go through the process of the proceedings. And the fundamental statement made here is that I'm not going to take my chances in respect of the jeopardy of criminal proceedings. Now, it's important for you to understand that criminal proceedings ordinarily create jeopardic consequences. And that's why in criminal proceedings, something they call double jeopardy. If you go through the trial twice.
Why will a business like Airbus, that has all the money, can hire the best of lawyers in town, decide to settle rather than get the best of lawyers to fight the case and win it?
Proceedings and criminal proceedings have dangerous commercial consequences for big companies. Companies will have to make calculations and do the cost-benefit analysis of whether it makes sense to fight or it makes sense to settle. Now, in settling, the fear may not be one of they feeling that they're guilty, but because criminal proceedings may entail these consequences that may affect their commercial bottom line. One of them could be the fact that there may be some disclosures and there may be some discoveries and other criminal compulsions that may be incumbent on them, and that may result in they having to make disclosures they do not want to make or undertake, for example. And some of them could be pricing, some of them could be persons they've dealt with, commercial partners, trade secrets, all kinds of things that may impact their commercial bottom line. And so they do considerations and calculations, and they come to a conclusion that it is more commercially sensible to just settle, not necessarily admitting that we're guilty, but admitting on the basis of whatever the plea is. And some of them could be, as I said, no contest. No contest indicating the fact that we're not fighting it. We do not admit guilt, but we're not fighting it. And we're not fighting it, and we're going to pay for whatever consequences there are. I think recently we had a similar scenario with COVID in the United States that is popular, that everyone might have heard about. So these agreements do not necessarily amount to an admission of guilt, but there may be collateral consequences and loss, especially for companies, for going through the process.
Right.
And they make the cost-benefit analysis of this, and they come to a conclusion that it makes more sense to, as it were, just close it by admitting something and then moving on instead of fighting the process.
Right.